Since 1960s, the women movement in Uganda has been engaged in a protracted struggle to have a legislation governing the family, which is underpinned by gender parity. The marriage and divorce bill continues to gather dust on shelves after it was rejected in Parliament, and largely the Muslim community, which found it offensive in their religious doctrine. The Makerere University Law Dons have found it necessary to unmask this complex subject through publications entitled The Divorce Law, a casebook for Uganda, and The Politics of Putting Asunder.
We cite the case of Chigongo versus Chigongo that recognize that irrespective of whether people are married but have made contribution to the property, they will need to share it equitably.
The Politics of Putting Asunder was authored by Uganda's leading law scholars, Professor Sylvia Tamale, Dr. Maria Nassali, Dr. Zahara Nampewo, Dr. Monica Twesimekirya, Dr. Harriet Diana Musoke, Dr. Damari Nagita, Patricia Atim, and Sewaya Muhammad.
Yes, the book traces the current divorce law that we inherited in 1857 and all the developments that the judiciary have put in place in interpreting the law to the current status that seeks to ensure that the current law is interpreted in line with the constitutional provisions that promote equality of men and women in a marriage.
Uganda too needs a family law that is protective of all its members and is non-discriminatory and promotes equality in all ways. Such a law must be sensitive to the changing social context and social justice.
The Divorce Law, a casebook for Uganda, was authored by Lady Justice Solome Barungi Bosa. While launching the publications that seek to inform policymakers and legal practitioners and students on issues surrounding marriages and divorce, in Uganda, the Deputy Chief Justice Alphonse Owiny said African societies had stronger marriage institutions, which was found repugnant by colonialists.
Among the central law, the women had to determine whether the war was just or not. The notion, the concept and practice of a just war was determined by the woman. However bad your anger was to retaliate for the wrong committed against you, if the women thought otherwise, you would not go to war. You own this abstract thing called home, but you have no control of the granary, which has got the foodstuff that feeds the family. In my tradition, a man would never open the granary. It was taboo.
Justice Owiny is of the view that if the intricacies of marriage is to be dealt with, there needs to be a review of the biblical commandments on marriage.
It says, thou shalt not covet thy neighbor's wife. There's no provision for the converse. Thou shalt not covet thy neighbor's husband. That provision is very loudly silent. So other than, fight to amend these laws of the world, these things, why don't we fight to amend the first constitution that was given to man?
As the marriage and divorce bill continues to face a fracas from the various sections of the society, it remains to be seen whether the informative treatise authored by the law scholars can shape debate on this veritable subject in a patriarchal society. Jingo Francis, NTV.